Hello, welcome to Property TV. This is Property Matters and my name's Stephen Galpin. Today we're going to be talking about surveyors and surveying and property values. Now, I'm very lucky to have with me today Jason Antill, who is Managing Director of PRE Surveyors. Welcome to you.
Good afternoon, Stephen.
Have a good journey in, I hope.
Yeah, not too bad at all. There
Good.
wasn't many people around, so
Great
it's
stuff.
good.
Well, look, I'm going to start off, funnily enough, by asking you about a question that somebody's written into us and that actually will be featured in one of our Property Question Time programmes, but it seemed to me a good place to start with yourself. And it's this really. So why is it when valuers come to value a property for mortgage purposes, they rarely value at a figure close to the selling price or the buying price, despite the fact that there might be similar properties in the vicinity that have sold at higher figures? Do you know, I've spent 40 years arguing with surveyors about values, so please tell us what we're doing wrong.
I think that's a great question. I think if you think about it also, is valuation an art or a science? And that's probably why the values could differ so slightly, because the valuation is based on that day, but also what is the comparables that you're valuing that property from? So, for example, you could have a swimming pool compared to the property next door, or you could have a loft conversion and so forth. So they could be adding on value that your property hasn't had the loft conversion. But when you come to sell the property, that seller may want some of that value back because you could get planning permission because next door's done a loft conversion as well. But coming back to that question about is it an art or a science, I believe it's more of an art valuation than a science valuation.
Right. Well, that's an interesting comment, but let's go a little bit deeper into that, and I'll perhaps quote something to you that I've experienced in the last few years. I had occasion to get a valuation, and I had a value around from one of the big lenders who offer very cheap valuations associated with their loans and services. Now, I think from memory it was probably £150 or something. And you and I know, because we've been in the business some time, that if actually you go to an independent firm of surveyors, a valuation at that level would probably be 1,000 and something, not 150. So naturally, the firms of surveyors who do this sort of bulk discount and very conscious of the numbers with a big lending organisation, do they think that the value should be adjusted so they stay away from any danger of overvaluing and being sued as such by the lenders?
When those types of valuations are done, and valuation in general, I would have thought they have to be quite conservative.
But that's hardly fair, is it, on the recipient of well, I suppose you're going to say, no, the bank are the recipient of the valuation. It's not really the house owner's valuation, is it?
No.
Although they paid for it.
No.
And that's sometimes a difficult thing to grasp, isn't it?
And it could be what we call is a drive-by valuation, where the valuer might not actually go into the property. It might be a drive-by where they look at the property from externals and they gather a lot of information. And also now with technology, a lot of these valuations are based on data being brought in, such as, I'm not going to name some of the big names,
Sure.
but you can use a lot of software to get you information or comparable information.
I mean, the argument I had actually was that there was an exact same apartment as mine, 3 or 4 floors lower, and he actually valued my apartment about £400,000 cheaper than the one that was sold 3 months and I think 2 weeks before, And his argument was he couldn't use that because it had passed the 3 months threshold. So it had to be within 3 months to be a comparable. And I argued against that. And actually, I spoke to your governing body, and they came down on my side with it and got it done again. And I had a successful valuation at what I considered to be the proper price. But it just occurred to me at the time that I thought it's very difficult for a sort of uninitiated person to start arguing with a valuer if they get terribly downvalued. And it's very unfair when they're probably their life's most valuable asset is debased like that.
I totally agree with you, but also it's what is that worth in the marketplace? So you do get, especially recently since the stamp duty saving, where prices have fluctuated, residential prices have fluctuated since the stamp duty saving.
And with the stamp duty saving, would that be, I know for instance when you as a surveyor would do a valuation, if say for instance it was a new property and there was a furniture pack given with it, you'd take that off, wouldn't you? You'd take that away from the value.
We're not there to value with items that could be removed. So we're not there to include the valuation if there is furniture
So
of those items.
Would the discount in stamp duty have any effect on the valuation or your judgment of the valuation?
Not on mine, no. No, that won't affect mine. We are looking at to work out the valuation. We will look at comparables.
Right.
But if the market is increasing in value of comparable properties, then we take that into account.
Right. Okay. And final question on that. I mean, it's, I suppose, quite specific to this area. I mean, here in Canary Wharf, we've got something like 20-odd thousand apartments coming on stream in the next year or two. A lot of these have been in planning, I suppose, over the last 5 years, and they're starting to come now towards completion. So do you look at the amount of properties that are actually going to come onto the market in future, or are you restricted to making your judgment at today's position?
It's at today's position.
Okay, so let me take you further on that one. If, say, for instance, a property has been the subject of an exchanged contract on plan, does that value count as a comparable?
So if you had that as a comparable, and then you actually then had a actual sale, that would be more stronger than that was done on
perhaps 2
plan,
years before, yeah.
But you take all that into account.
You would. So,
yes.
So you would consider an exchanged contract on a to-be-built property as a slightly lesser comparable, but nevertheless taken into account.
Yeah, you would take that into account.
I think there'll be a lot of very relieved people to hear that, especially in this area, because it has in the past, when we had the 2010-11 crash, wherever you want to identify it as, I think that became a huge issue, again, especially in these sort of areas where development was really rife and so many people had booked to purchase a property, probably getting loans from overseas banks as well as UK banks. It becomes quite an issue. And I know I was involved in some of the developments down here, and I mean, just spend my days arguing with valuers about what you would or would not take into account. So it's quite refreshing to hear that there's perhaps a little bit of a change there. And going on from there, I know this is not your specialism, but do you have a view about property finance for the next few years, given what we've gone through with COVID, with perhaps, although I know construction has carried on, we've had a little bit of a stalling of provision of property stock, probably just coming to market a little bit slower than before. What do you think the lending prospects are over the next couple of years going to be?
Lending will also be based on your income. So depending on your income, if it increases or decreases, but also the government has put in place that first-time buyers buying at 600,000 or less can get a government-backed mortgage where they only have to put 5% deposit down. And I think that is coming to an effect shortly. And I think that would be very interesting to see on the take up of banks that will be accepting those
Well, I know
lending. So
when I bought my first property about 100 years ago, I mean, 5% deposit was quite normal, if not borrowing the whole amount. Do you think we'll head back that way?
I don't think we'll head back that way because of the risks of the banks. I don't believe that they will take that risk back on since what happened in the crash, as we spoke about, 12 crash. What is difficult, and I think we'll see more of, and this is probably why the government has stepped in, is that people will just continue to rent first-time buyers, because for them to get onto the property ladder is very difficult.
Well, the problem with long-term renting is when you come up to retirement age and you're still paying a commercial private rent and your income stops and you go on to a state pension, you're going to become a sort of liability to the state, aren't you? I suppose it's as simple as that, really. Yeah. Okay, Jason, that's very interesting. Thank you very much for that. That's all we've got time for in this part of the programme. In part 2, we're going to be talking about these dreaded EWS1 forms. Join me then. Welcome back to part 2 of Property Matters. I'm Stephen Galpin and joining me is Jason Antill of PRE Surveyors. Welcome back, Jason.
Hi, Stephen.
Okay, well, I said what we'd be talking about, which is this dreaded EWS1 form. Now, for the uninitiated, this is all as a result of the terrible Grenfell incident where a tower block burnt down effectively because of ineffective cladding in terms of fireproofing. The repercussions have been immense and the inquiry is still ongoing, I believe. But what it has done, it's caused a need for a specific form for the tower blocks now that are over, I think, is it 18 metres tall?
18 metres, yeah.
18 metres tall, to have this fire certificate before those properties can be sold and subsequently mortgaged. So, Jason, we're hearing all sorts of stories about this, and I suppose perhaps the starting point for this is where you have perhaps a residents' association or a number of owners get together and say, right, well, we need this certificate. We're going to employ a firm of surveyors to come and do the checks, check our cladding and various other things, and we'll come on to those other things in a moment. And then the freeholder or the developer also decides he's going to have somebody in to do the EWS1 form, and the two conflict. One says, no need to do anything, and the other says, this is a problem. So who wins?
The issue is that the landlord owns the building, or the freeholder owns the building, and the long leaseholders, which are the occupiers, are leaseholders. And you've got also the fire risk part of things, where the long leaseholders can write to the freeholder and say, we've had this work carried out and we believe that there is or isn't a risk and that the cladding doesn't meet EWS1 form, and that we would like this to be put in place. The freeholder should carry out.
So the freeholder is under an obligation then to do that work?
If that building fails the EWS1 form, that has to be done. However, in the leaseholder's obligations, repairing obligations, it's very unlikely it would state that within the service charge that the leaseholders will have to pay.
We're hearing stories of a lot of people getting £50,000 or £100,000 bills even to have this work carried out. And I mean, I can only speak for my own particularly. I suppose over the years I've seen many leases, but my particular lease will say that your responsibility effectively finishes at your plasterboard finish in your flat. However, there's usually a sort of catch-all clause that says anything that the landlord or the freeholder has to do, he can get reimbursed for via the service charge. But what I'm really getting at is if in a counter to your efforts of having the survey done and finding these problems, he has one that's done and says, no, 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 there's no problem. Which one wins in law? Do we know?
Well,
Have we had any test on it yet?
if there's a conflict, then you need to go down the proper route of coming to an agreement. I think
Who would be the arbitrator?
that's a very good question. It's something that you need to get solicitors involved in
Right.
and to come to an agreement. But I think you always, unfortunately, have to go back to the lease. I find it, I don't think there's many, not that I know of, but you might know of cases where they're conflicting, saying the building has been signed off with an EWS1 form, and then the landlord saying no or yes, the EWS1, because the people that are signing off these forms, they're professional body, they're represented by a profession and they have professional indemnity insurance.
Sure.
So they must come out with the same answer. It's very unlikely that you'll come out with
Well, I
a
know
different answer.
there's a building in Portsmouth at the moment that's actually been headlining this. That the people there have had a survey. The calculation was it was going to cost them about £50,000 per leaseholder to get done. And the landlord has come back and said, no, I've had a separate one done and there's nothing wrong with the building at all. Now, actually, I mean, I would find that a very brave statement to make, because I would hate to be 2 years down the line, disaster happen, and having sort of made that kind of commitment that nothing's wrong. So I mean, I think it's a brave thing to do. And you know, conversely, you get very good landlords, freeholders. I mean, I know, for instance, Taylor Wimpey have come out in the papers recently and said, look, we're just not going to let our tenants, our long leaseholders, our owners to suffer these costs, and we're just going to remedy whatever is needed. And that brings me to my sort of next question with you is, look, question of liability here is very difficult, isn't it? You buy your flat or your house, you have your solicitor do what's called a report on title, and he's supposed to dig up and make sure everything, you know, corresponds with the lease, everything is in order, the necessary building regulations have been supplied. So if it doesn't quite match up, is your solicitor negligent in that case? But then let's just leave him for a minute and let's go back and say, well, look, well, the developer built it, so he must be reliable. Well, that's all right, except the builder has relied on what the local council has said, these are the regulations that you must adhere to. So let's leave the developer, let's go to the council. And let's say, well, are the council responsibility because they put in a poor set of regulations which didn't protect me? So where does the buck stop here?
Well, for that, we need to go back to the lease again and see who is responsible for what parts, but also the government is trying to assist. So they're offering over £1 billion worth of grant funding to cover repairs, and that is something that the freeholder should be overseeing.
Right. So now, is that a grant to the developer or the freeholder to get work done?
Correct. Yeah.
But is there not in tandem a package of loans that are available to leaseholders if, in fact, they are stuck with this awful liability?
I don't think there's any loans. I'm not too sure about that. I know there is government funding for the works to be carried out.
That was probably a wish list, was it?
Yeah, and for professional fees.
Yes,
to be paid.
It is very difficult, because even in the Taylor Wimpey scenario, where they say we're going to pick up all the costs, they were very clear to say what they're not going to pick up is the costs of, say, of perhaps fire watch personnel who march the buildings at night to make sure and protect. So, and I mean, that on its own can be quite substantial, can't it?
Yeah, that is a large amount. But that would only be in place if your fire alarm system wasn't up to the specification that is needed.
Yeah. Now, coming on to these EWS1 forms directly, is this to to assess and fill out this form, if there isn't what I'm trying to get at, is there a blanket one for the building, or is each apartment given an EWS1 form if you're in a multi-block, for instance?
Okay, so the way it works is for a fire engineer or a member of the RCS who is shortly going to be allowed to sign EWS1 forms, but originally it's the fire risk assessor or fire engineer, they would carry out a intrusive survey, and what that would entail is the fire compartments externally and the cladding samples would be taken, or holes would be made into that building for us to see where the cladding is, and also any other information that we need. When that fire risk assessment report's been produced, that will then allow someone to decide if it's a fail of the entire building or if it's a pass. That EWS1 form can be given to every single person within the flat, and if they need a side letter addressing it to that person, that's something that you can also provide. But it's for the flat itself, or for the property itself.
Okay, so really, again, that's, I suppose, a freeholder responsibility to procure that document, isn't it?
Yes,
really?
it is. Yes.
Otherwise, like where I live, you'd have sort of 500 or 600 different other people trying to all get one.
You would need landlord's permission before you start carrying out your own intrusive work,
especially if it differs from what he'd had done. Yes,
you'd really need, and that would be put through the service charge. So again, it would be something that the occupiers would pay. However, if this is something that the freeholder can get a government grant for, that is something that would pay for something like that.
Okay, so going full circle to what we were talking about when we first started the conversation about valuations being done for mortgage purposes, where does that surveyor get the information about the EWS1 form from? Is it a matter of public record, or is it?
So that would be, each document would be given to the, first of all, it would be held on file. So with the managing agents.
Managing agents,
yeah.
Got it.
So the managing agent would have that form, and that is something that if you're going to purchase the property, you would request. However, mortgage companies are requesting these themselves.
Okay.
So they are specifically asking for that form.
Okay, so I suppose really, the managing agents are going to have a bigger role here. The surveyor's got a bigger responsibility in making sure that it's there for his lender and for your lender. Now, I read in the paper some weeks ago that the government were, I think their phrase was, hoping to assist with the easement of responsibility on these forms. Was that where you were referring to, perhaps, that RICS are going to be able to sign these off now?
Yes, so at the moment there's only a few hundred engineers, fire engineers, that can sign off under their professional indemnity insurance or qualified to sign off EWS1 forms. So the RICS is now giving out or allowing up to, I think, 300 or more surveyors, building surveyors, to go on a course and then be allowed to sign off these certificates to try and push through more buildings that may be 18 metres or may have combustible material in.
Okay. Well, Jason, Antill, thank you very much for that information. I'm sure that's helped a lot of people get over the mystery of these forms. I think what I would say is that, yes, we have these safety forms now, and it's a great incentive to make developers and make us all more responsible and think about the fire risks of our building. But again, we all have to learn to live better together. Densities are getting tighter and tighter. People I see across the country are putting things like washing out on balconies that are a real fire risk. Fire alarms are not always being kept up to speed, so we all have a responsibility. And just remember, if it's your bicycle that's in a fire exit area and stops people getting out, just think of the consequences of that. Anyway, that's Property Matters. Thank you very much for watching. I'm Stephen Galpin. Thanks again to Jason Antill of PRE Surveyors, and see you next time.